So the question was, what about other federal programs like Medicaid or Medicare? So Title IX only applies to educational institutions. That said, there are other laws that would apply in that situation, specifically Section 1557 of the Affordable Care Act, which is the Affordable Care Act's non-discrimination provision, which also prohibits discrimination on the basis of gender identity in any healthcare institution receiving federal funds.
When you say it's your interpretation of Title IX, for us lawyers, does it specifically say gender identity in Title IX?
No, it says sex. And so the evolution of that it has been, the Supreme Court in Price Waterhouse expanded it to sex stereotyping and failure to conform to notions of masculinity and femininity, and that's really expanded, especially in the context of Title VII, where the EEOC and many federal courts have made the direct link between sex and gender identity. There's a great case, Schrader, out of the District of Columbia. A trans woman was offered a position at the Library of Congress, told her employer that she was transitioning, and then the offer was rescinded. And the district court said you discriminated against her on the basis of the fact that she failed to conform to sex stereotypes, but also that she changed sex, right? That she was initially identified as male, but is female.
With the law stating that they technically do have to keep up with what's on your birth certificate, does that include having to use your birth name in roll call?
So does it require the use of your birth name in roll call? And that's where we would say no, right? That Title IX requires the school district to create a safe and welcoming learning environment. And for trans students, it includes using their chosen name.
Can I add something? I just want to say also just in common practice, in my experience in K through 12, there were plenty of people who, for example, went by middle names, and those were the names called by the roll, those are the names on the grading register, those are the names they put on papers. So this really isn't groundbreaking that people go by different names at all.
So getting on to privacy and student records. Student records, again, must reflect the person's chosen name and gender marker. Sometimes, as I mentioned earlier, the school has to maintain a permanent pupil record, but there are lots of ways around it. Lots of states say they have to maintain a record, but it doesn't say it has to be on every piece of paper, right? So what we typically recommend is that the school keep a copy of the student's birth certificate or whatever it is, under lock and key in the principal's office or the district office, but all the documents that the school district generates has the correct name and correct gender marker. And the story that I like to share with this, because again, this is one of those things that people feel like it's not that big of a deal. I represented a trans guy in Southern California who had just moved to a new school district, a new school. He has a Vietnamese name, which most his classmates could not identify as either male or female. And so he just went by a nickname, and that was his name. The school used students to bring down the attendance sheets from homeroom. And one day, one of his classmates noticed that he had an F marker by his name. She took a picture of it and posted it on Facebook and outed him to the entire school. And after that, the bullying started. It got worse and worse. And one day, he fought back and he got expelled. Right? So, individually it may not seem like all that much, but it can really snowball and result in really severe consequences. Another thing about the school records is privacy, which sort of ties the story in this next point, is school districts have this weird belief that if a kid is transgender, everyone has the right to know, and they don't. It's actually none of their damn business. And that's really important to be clear with the school district about. Particularly if you're representing a family, what the family is comfortable with. You know, some families want to go in totally non-disclosed. You're not even talking to the school district. Some families will want the principal to know, but nobody else. But it's really important to lay out those limitations. And what we encourage school districts to do is to have a conversation with the family if they believe that someone else should know. So for example, we represented the student in Arcadia, which resulted in the first resolution agreement with the Department of Education, Department of Justice, recognizing that Title IX applies to transgender kids and requires that they be treated equally with their cisgender peers. And in that case, the parents really just wanted, he was moving to a new school, parents really just wanted the principal to know. But once he started using the boys' facilities, the principal really felt it was important for the physical education teacher to know, just to keep an extra eye out on him when he was changing the locker room. And that started conversations back and forth. And eventually the family agreed. They said, fine, we'll disclose to the physical education teacher, but we want to do it under these conditions. And their conditions were that the principal was going to invite the physical education teacher to his office, and they would make the disclosure there. So they were able to control how the disclosure was made. And they did it in a context where the principal was basically there and saying, like, look, this is, you know, reiterating, this is private information, it's just for you, we're telling you for this very specific purpose, and you're not to tell anybody else. And so having a sense of what your client wants or what you want as a parent and what your child wants is really critical before you go talking to the administration. Another thing is, for some reason, school districts believe if they're going to keep this private, that your child has to keep it private. And that's also not true. They cannot restrict, that is a violation of the First Amendment, they cannot restrict your child's ability to disclose their gender identity. And for that very reason, that's why we say, you know, even in the most private of transitions, you need to plan for it to be public. Because you never know. I mean, it's wonderful, right? I worked with this one second grader who was bullied terribly in one school and had so badly he had to move to another school. And for the first few months, he was like really, you know, closed off, didn't want to tell anyone about his trans identity. But he's proud about being trans. And so he, you know, after a few months, he started feeling comfortable, he started telling everybody, you know, and so you just need to be prepared. That's your job, that's the job of the school district, is to be prepared. So where are the, oh, sorry, go ahead.
I'm not getting ahead of you by asking this question now, but I wonder if you could talk, you're mentioning families a lot. And I'm a teacher and I've worked with trans students who do not have supportive families. How does this law apply when they don't have families advocating for them? Can other people advocate for these legal changes?
That's a great question, and I am going to get to that later about what to do when families are not supportive, whether there's a disagreement between the parents or both parents, you know, one or more parents are not on board. So where's the implementation gap? Oftentimes school districts will complain that their database, their student database, has to sync up with the state database. First of all, I've never seen a school district be disciplined, fined, anything for not having a perfectly matching database, right? It just doesn't happen because they don't care. But beyond that, you know, if the school district's really concerned about that, we're not talking about a whole lot of students. And so what some school districts will do is they'll have all the correct information in the student information system until they have to upload. Then they switch it to the legal name and gender, do the upload, and then switch it back. Right? So there are ways around this if that's a concern. But it's really a matter of, you know, where there's a will, there's a way. And you just have to find the way that's going to work for that particular district, how they maintain their records, and do all that kind of stuff. So, and then again, to go back to that story, the failure to have the consistent records, you can out a student, and that can have really damaging effects. You know, and you also have to be prepared for it to appear in unexpected places. I remember one kid that we worked with, they were using, which is obviously not good practice anyway, but they were using student roll sheets as scrap paper. And there she is in her first or second grade class, and she's pulling up scrap paper and she sees her name on it. You know, and that, you know, was really scary for her because what if someone else picked it up? What if someone else picked up another version of it and saw her name? That's really scary. It also appears on state testing booklets. And this is one that schools love to, is really motivating for schools, because if you have a trans kid who gets the state testing booklet with the wrong name and gender marker, they're not paying attention to that test. They're focusing on making sure that no one else sees that the wrong information is on that testing booklet. And I will tell you, in Arcadia, what they did, because that happened with our client, they pulled out his testing booklet before testing began, and they switched the labels, right? We're not talking about a tremendous amount of kids. And so with a little bit of effort, you can really get around the biggest pitfalls. But it can also show up on things like school photos. Whenever whenever a school district uses a third-party vendor, these things can come up. And so it's better to have it correct in the system so that doesn't really happen, so you don't have to worry about it. The one thing I will say about privacy claims that can be tricky, particularly in the social media age, is that the basis for a privacy claim is that they have a reasonable expectation of privacy. If your client is posting on Facebook that they're transgender, they probably don't have a reasonable expectation of privacy with regards to a lot of the areas in the school. And so that's something to consider. There are certainly situations where you can claim privacy in one area, in one context, but not have privacy in another. So it's going to be a really fact-based analysis about whether or not your client or child has a reasonable expectation of privacy. Any questions about that before I move on? Okay. All right, the fun stuff. Sex-separated facilities and activities. This is where everyone has lost their collective mind. Legislators can't file bills fast enough to ban trans people, trans kids, whomever. They're just like flipping out. There was, I think, my favorite, I'll put that in quotes, my favorite, there was a legislator from Tennessee, or maybe it was Alabama, who said, if I catch a transgender woman in the changing room with my girls, I'm going to stomp a mud hole in his face. Yeah. And I think someone recently repeated, one of these other states repeated a similar threat of violence. And I will say, one of the things that it's really important to talk to school districts about, that vitriol comes out all the time, and school districts need to be prepared. You can never over-prepare. They really need to be prepared to address these concerns, because parents will bring them, and if they get enough people, it can really overwhelm a school district, and I'll talk about a situation where that happened. Okay, what the law requires, very simple. Give students access to facilities, activities, and programs based on gender identity. I tried to come up with an exhaustive list. I think that pretty much does it. Restrooms, locker rooms, overnight field trips, prom, homecoming court, athletics, and dress codes. Those are the big ones. If I've missed any, let me know. And the bottom, the last one, the last sort of bullet there is also really important. School districts cannot aid and abet discrimination. And what does that mean? They cannot be complicit in discrimination. So one of the things we often hear with these overnight field trips, oh, well, we go through a travel agency, and that's the travel agency's policy. Well, too bad, you're going to have to find a new travel agency. Or tell the travel agency you're pulling your business if they don't change that policy, and then you'll see how fast they change it. And that's one thing that, interestingly, in Arcadia came up, because we were in California. California has its own really strong anti-discrimination law, so I called up the camp where they were going, and I said, look, camp, you have an independent obligation not to discriminate. So you can't let the school district do this, because what the school had been telling me is that this was the this was the camp's policy, and you can't And then what the camp said, the camp director told me something like this, something to the effect of, I'm a lesbian, I totally get it, but I can't help you. This is what the school wants us to do, and we're just going to follow it. So they did one of these, right? So we ended up not filing a lawsuit against the camp, although we could have. This matter got resolved amicably, but that's what we mean when you can't aid and abet discrimination. So how to talk to school districts about this? I mean, I think this is the area where school districts have so much fear And I think one of the reasons why school districts have so much fear about this is, for their entire lives, these adults have believed that they can rely on things like hair length, body type, clothing to determine who should be where. And what you're telling them is not only can they not rely on those things anymore to really determine which bathroom or locker room a person should be using, but now we have to rely on what they're telling us is where they want to be, right? And so it's like, wait, I have to trust kids who don't know anything about anything, and that's very scary to them. And so how do you sort of bring down that fear? And I think one great way to do it is to take the trans out of it, right? Sort of get them to step back and actually look at our cultural practices. And one thing I'd like to ask school districts is, how many of you have ever had your genitals checked before you go into the bathroom? Right? Predictably, no one raises their hand. If anyone ever did, I'd say, look, I've got a number for a good lawyer for you. Because that should never happen. People access facilities based on gender identity. We do it now, we always have done it that way, right? And you can even see it even among, all those stories where you have these really butch, masculine appearing lesbians going into the women's restroom and then being kicked out because they look like men, right? Or even there are a lot of trans guys I know have the experience of before they even transitioned, they were getting kicked out of women's facilities because the women in there were like, you don't belong in here, right? And another thing to talk about too is if you were to have any other policy, it'd be overly invasive and unworkable, right? If the school was checking students' genitals before they went to the locker room, they'd have much bigger problems than a trans kid using the restroom, right, or locker room. And it's also unworkable. Like, are you really going to have someone monitor? You just can't do that. And I think one of the things that we as a society has done is by separating, men's facilities and women's facilities, we've gotten lazy and are not educating people about don't be a jerk. Respect other people's privacy, respect other people's space in these communal restrooms, in these communal facilities, and really focus on school culture. And then from there, obviously they're still worried about this parade of horribles, right? The boy who claims to be a girl just to get into the girls' locker room to peep and all that stuff. So what I'd like to talk about is there are millions of students who are going to schools every day where transgender students are given access to facilities based on gender identity, and none of that has happened, right? None of that's happened is because school administrators already have the tools they need to effectively implement trans-inclusive policies. They just need to know how to apply those tools to this new context. And actually, interestingly, the one issue that has come up, the Pacific Justice Institute, which is a religious legal organization in California, represented 3 families who were complaining about a transgender girl allegedly harassing other girls in the restroom. That's a problem, because no girl should be harassing other girls in the restroom, right? So the school district was concerned, they investigated, and the school district found out that wasn't actually true. And the Pacific Justice Institute then backpedaled and said, oh, well, her presence alone in the bathroom is harassing. And the school district said, okay, that's nice. And then said, if your clients are really concerned about their safety or want just additional privacy, they're more than welcome to use the nurse's restroom or a single-user restroom around the school. And the Pacific Justice Institute got incensed. They're like, how can you make our clients walk all the way down to the other side of the school, and miss class time and all this stuff, not really realizing that they were just undoing their argument. So the big what ifs. It's always important to be prepared to address the big what ifs. The first one I mentioned is, what if there's a boy who goes to the girls' locker room? And boys in their adolescent minds will do stupid stuff. They've done it before this happens, before you institute a trans-inclusive policy, and they may continue to do it afterwards. It has nothing to do with a trans-inclusive policy. It has to do with school culture. And the other thing is reminding them, like, when you were a kid, you did something bad and you lied about it, that didn't get you out of trouble, it just got you into more trouble, right? And so if a boy goes into a girl's locker room and then claims to be transgender in a way to get out of trouble, they're just digging the hole deeper, right? You know, another one is, you know, what if kids start looking under the stalls? Okay, kids shouldn't be looking under the stalls. That's a problem, right? You need to address it on a school cultural level. It's not okay that kids are looking under the stalls. My favorite has been, what if kids start having sex in the bathroom?
There you are.
Well, and then my response to that is, you should make your classes more interesting. You know, it's just, you know, it's about school culture, right? I mean, you just need to make sure that, you know, that's inappropriate. They shouldn't be doing that at school time. You know, another big one is safety. And there are sort of two sides to this. So first off, you know, when I talk to parents, I say safety first, safety last, right? Just because you have a legal right to be in the restroom doesn't mean it's necessarily safe for your child. And you want to make sure that that's where they want to be. Because I've definitely seen some parents going guns blazing, I want my kid using the right restroom. Kid's like, actually, you know, actually I had one trans boy say to me, actually the boys' restroom's kind of gross, I don't want to use it. Which I can't really blame him for that. But so it's important to sort of make sure that your client feels safe and that's the restroom that they want to use. But if they do, and the school says, you know, well, we can't keep them safe in the bathroom, well, that's a real problem, right? And then to say to the school, like, are you telling that to all parents? Because if you can't keep kids safe in the bathroom, you've got big problems, right? This is a big issue that you need to address. And really, those kinds of things, if you can get them to take a step back. Oh, this is another good one. The locker rooms. You know, what if a kid feels uncomfortable changing next to a transgender kid, right? What do you do? Well, what do you do if a kid feels uncomfortable changing next to a kid who uses a wheelchair or wears some kind of religious garb that is offensive to that student, right? You talk to the student, you try to get them to get over their discrimination, and if you can't do that, then you move them, right? This is not rocket science. You know what to do. You just need to realize that, you know, just because it's a trans kid doesn't mean it's all of a sudden that much harder. It's the exact same thing. And then when it comes to overnight field trips, the one thing I would add to that is showers. That becomes a big issue, like what to do, especially if you're going to a camp setting where there's only communal showers. So what we suggest with that is actually make that communal shower a large single stall shower for certain periods in the day. Because let's be honest, I mean, how many people do you actually want to shower in front of your peers? Very few. You know, in high school when you're getting changed for physical education, you changed as quickly as you could and you got out of there. And, you know, so setting that up so that there's a private area for folks to shower or even changing, that's another thing. We've found that schools who set up changes, you know, special privacy curtain, the trans kid has a really hard time using it because all the other kids want to use it too. And actually, I saw an article unrelated to trans anything in the New York Times about how kids are becoming more and more modest. And reading the article was actually shocked. It talked about how in the 1940s people would, you know, take swimming classes totally nude, and that was just like, I don't actually believe that happened. I think they're lying. But it was in the New York Times, so it must be true.
So a lot of the schools still operate in a binary system though. So what about the rights and protections for kids that are non-binary or gender fluid or genderqueer?
Yeah, great question about non-binary, genderqueer kids. And I think the difficulty is that our society, unfortunately, is very organized by gender, you know, male and female. And so what we often talk about with families with non-binary kids or the young people themselves is they need to figure out what makes them feel most comfortable, right? And what we advocate for is to create gender-neutral facilities throughout the school, right? Because trans kids, non-binary kids are not the only ones who want to feel comfortable, want more privacy when they use the restroom. So having those options available to all students is great. Ideally, there would be some gender-neutral communal restrooms if we could all get along and not harass each other in the restroom, which is apparently a big deal, that's really what we advocate for. And again, but with sex, sports is a similar thing. Just don't. And I think it may ultimately come down to, what sex steroid caused your puberty is sort of where they may end up. So I do want to talk quickly about sports too, because that's another huge thing. We saw with Texas recently, the Texas UIL, the University Interscholastic League, amended their bylaws to require that all students' access to sports is based on the sex on the birth certificate. And we worked with Lambda and the ACLU of Texas to send them a little nastygram telling them that was a bad idea. Let's see if they listen. But a lot of states actually have that. Not just states in the South, but there are actually 15 states in the United States that allow trans kids to compete based on gender identity. And some of them are unexpected places. Virginia, Florida, South Dakota, all allow trans kids to compete based on gender identity. And Virginia, I will say proudly, used to have a surgery requirement. They actually required surgery, not just a gender marker change. They actually required surgery in their policy. And we got them to change it along with working with the ACLU and a couple of other local organizations in Virginia. And that policy's been working out great. Some of the things that come up around sports is particularly there's this belief that if you allow trans folks to compete based on gender identity, that some school is going to be able to field a team of hulking trans girls that are just going to destroy the competition, fly to states untouched. It doesn't happen. That's not a thing, right? What we've seen is the state of Washington has had gender identity, gender inclusive sports policies since 2008, and they've had literally a handful of students. So we're talking about a very small number of students. And then obviously the competitive advantage, particularly now with Caitlyn Jenner, everyone's worried that Caitlyn Jenner is going to start competing in high school sports. And what does that mean? And the problem is our focus on the difference between boys and girls totally obscures the difference among boys and among girls, right? And what we've seen, two things. First of all, the trans kids that we work with, their size and skill level fit right within their cisgender peers. And the reality is, if you have a good athlete, they're going to be a good athlete. That's just their reality. As I like to say, I fancy myself a decent soccer player. Regardless of how hard I trained, I could never beat any of the women who play for the U.S. women's team. It's just my athletic abilities are not theirs, and theirs far exceed mine, and I'm okay with that. And then lastly, just as a quick thing, the First Amendment really prohibits, around dress codes. You can't police students' dress codes. As long as they're complying with the dress code that's consistent with their gender identity, you have to let them dress. Bullying, harassment, and discrimination. I'm going to start to speed up a little bit because I see time flying, surprisingly. So these are the elements of what a hostile school environment claim looks like for the lawyers out there. It's extraordinarily high. The school district has to act with deliberate indifference to known acts of bullying and harassment that are so severe and pervasive that interferes with the student's ability to learn or access the educational program. In parentheses, I put in some additional qualifiers that make it even harder. It's not just actual notice to anybody. It's actual notice to a responsible person, right? So that responsible person is likely going to be an administrator. Depending on who does discipline in the school, it may be a guidance counselor, but it's going to be school specific. And it has to be actual notice, appropriate person. And then it also has to be severe and pervasive to a reasonable person. So, it may be severe and pervasive to your client, but if it's not going to be severe and pervasive to a reasonable person, then sorry. These are the elements of the cause of action, regardless of who the aggressor is, if it's a peer or a series of peers or a faculty member or school personnel. These are incredibly hard claims to make. Particularly because of the actual notice requirement. Schools don't keep good records, especially if it's going to get them into trouble. and parents often trust the school a lot to keep these records, and they don't keep them themselves. So you could also have a direct discrimination claim, whether it's discipline, school push-out, failure to respond to reports of harassment. These are essentially, there are can be Title IX claims, but they're also equal protection claims, right? That you discipline students, transgender students more harshly, that you push them out, instead of dealing with harassment, you just push them out. You can't do that. That's discrimination. So where are the implementation gaps? School personnel often do a lot of victim blaming. If you weren't such a faggot, if you weren't so flaming, if you weren't so this, or what did you do to provoke it? And sometimes kids fight back, and so the school says, well, you fought back. What do you expect them to do? Just lie there? The standard of liability is really, really high. And so you have to get really egregious cases. One of the cases that I like to use as sort of an indicator of how bad it has to be is a case that Lambda brought back in 1996, or the early 90s, on behalf of a gay kid, Jamie Nabosny, who was tormented for years. And the principal said things, if you weren't so gay, this wouldn't be happening to you. He was mock raped in class. He had nuts and bolts thrown at him. He was jumped and beaten so severely he had to be hospitalized. This went on for years. Now this case ultimately settled after a trial for nearly $1 million. But that's how bad it has to be in order to succeed on a hostile school environment claim. And then, as I mentioned earlier, the proof problems. Schools aren't going to keep records. Family likely doesn't have records. And then supportive teachers and peers are unreliable witnesses, especially if they're moving away, going to college. Teachers reasonably fearing for their jobs. So there can be lots of impediments to bringing a claim like this.
I would like to go back to that. The school system has been, before they take accountability to what the student goes and reports and says, they call me a faggot, and there was even, very good to speak up and heard the name calling, and then when it's reported, they said, well, you have to have 3 witnesses.
Well, okay, so the question is, what are the school's obligations when they get a report of harassment requiring 3 witnesses? I think that this is the difficulty, is that they're not responsible because the harassment happened. They're responsible for failing to address it. And so it's irrelevant, really, how many witnesses you have, right? If it causes a hostile school environment, then they're liable. If it causes a hostile school environment because they failed to address it, that's what makes them liable. And so what's going to be critical from your perspective is just document it. I don't care if there are 3 witnesses or not. This happened, and it's important for you to know about it. And one thing to sort of point out, particularly if your child is not only trans, but also identifies as LGB, and they're experiencing harassment about their sexual orientation. Unfortunately, the Department of Ed has been pretty strict about it has to be sort of gender related. So there was a case, Seth Walsh from California, a kid who was also harassed horribly and ultimately died by suicide. The reason that the Department of Education got involved in that case is that he was being called a sissy, he was being made fun of for wearing nail polish, that he had mostly female friends, those kinds of things, not because he was gay or identified as gay. So complex issues. To get to your question about, I talked about special education first, but here, okay, Paracin Conflict. Really, what we talk to school districts about in this case is they still have an independent obligation not to discriminate. And so what that looks like in this context is a school meeting with the student and saying, what can we do for you to feel safe and affirmed when you come to school, right? What can we call you by a different name? Can we let you use the correct restroom? What can we do? And then talk through what the options really mean. Like, okay, we're happy to give you the access to the boys' restroom because you're a trans guy, but what will happen if you go home with a friend and your friend says, oh, hey, Mrs. So-and-so or Mr. So-and-so, did you know your kid was using the boys' restroom? Are you still going to be safe, right? And the purpose of this conversation is not to dissuade the student from doing it, but to get them to think through the consequences and make sure that they feel safe with all the options. Schools should engage the parents in a dialogue, right? Parents are just as afraid as schools are. As I like to say when I talk about family law, having a trans kid is not in the book of what to expect when you're expecting, right? Parents have no clue. We finally gotten to the point where parents finally think, okay, maybe my kid is gay. And often parents of trans kids think, oh, maybe my kid is gay. And sometimes trans kids will come out as gay first, right? So, it's really important to do that education with the family and say, look, family rejection leads to much higher rates of substance use, all these bad things you don't want for your kid. And on the converse, affirming your child has all these really positive things. And really try to get them to become affirming. And if you're in a situation where one parent agrees and one parent disagrees, the school can be a really great resource if this ever comes to a custody modification situation where the non-affirming parent is suing to get more custody or to limit the affirming parent's ability to affirm their child. And I will say, I use the terms affirming and non-affirming because the non-affirming parents will say they are supportive, right? We had one case we worked on where the dad was like, look, I love my kid. If my kid wants to be transgender, great. I'm just really worried about them getting their asses kicked in school, so I want them to be sure before they do any transition or anything like that. So they're saying they'll say they're being supportive, but in reality they're being non-affirming. Okay. Special education, really quickly. I actually started in this work as a special education lawyer, and I think it's a really useful tool to get trans kids what they need. Trans kids can be identified as a student with a disability for a whole host of reasons. Some related to gender dysphoria, some entirely unrelated to gender dysphoria. But you can still use that process as a way to advocate for kids. So first of all, just as a quick thing, gender dysphoria is actually explicitly excluded as a disability under 504. You can still use anxiety, depression, the sort of manifestations of that dysphoria as a basis for a 504 plan. I would also say as a little footnote, I think that exclusion violates the Constitution. It can't be enforced, but if you have a case and you want to bring it, call me. And there's no such exclusion under IDEA. Okay.
Can you talk a little bit about the ethical implications of using a tactic like this, just in terms of classifying trans students as students with disabilities when that's not necessarily the rhetoric that a lot of people will internalize for themselves?
Sure, and that's a really great question. The question was about the sort of ethics of using a disability discrimination model or a disability model with trans folks. And I really leave that up to the client. From my perspective as a lawyer, as an advocate, it's a really great tool. I recognize for some families it does not feel good. And we also talk about the difference between disability as a social construct and disability as a legal construct, right? It has a very different legal definition than it does social definition. And also to some extent, if you are though looking at the sort of social stigma model of disability, it does kind of fit in that way. There's a really great piece that Jennifer Levi co-wrote with, I can't remember who else, in an edited book called Transgender Rights that was edited by Paisley Carra. I would highly encourage you to look at it if that's something you're interested in.
Can I make a comment on that?
Yeah.
So I did want to add, in relation to people being unwilling to use disability rights as an avenue for transgender rights, I think some of that does stem from ableism within the transgender community. So that is something that people really need to examine when they're considering that. And also that disability rights as sort of a legal construct really do focus on the idea that society is not structured to support these people, and that is 100% the case of transgender people.
Which is exactly, the social stigma model of disability. And I think, one of the great things about IEPs and 504s, you can really drill down and get what your kid specifically needs. So if it's stress breaks, great. We worked with a family whose child had really severe school phobia, could not even walk into the school because of 3 incidents of bullying and harassment that he'd experienced. And all the school district did was pay for him to go to a nearby public school. No supports, nothing else, just the transportation and the tuition to a nearby school district. He did fantastically, right? All he needed to do was to get out into a new environment where no one knew that he was trans. And, you know, on the flip side, there are some kids with really significant mental health issues who are also trans and need residential treatment, right? This is where it comes into the aiding and abetting discrimination again. You know, you have to send them to a residential treatment facility that's going to house them consistent with gender identity, because that's one, aiding and abetting discrimination, but more importantly, it's not providing them with a unique educational program that's tailored to their unique needs, right? It's not going to result in any educational progress because they're not going to be able to focus on the educational program at all. And one thing I often talk about too is eligibility should be done in a time-sensitive manner. You know, school districts will often insist they have to do an assessment first before they do any eligibility. That's actually not true. There's a sort of an opt-out provision where you can create eligibility based on existing data. And so, for example, if your client's been hospitalized in a psych facility or has a long documentation of a real severe need, you can create an IEP without doing an evaluation. Actually, I would encourage it, because especially if it's being done in conjunction with a kid's transition, you're going to get a totally different kid after that kid transitions. And so you're going to want to do the special education assessment after that point, so you're getting a much more accurate read on who they are. There are a number of stories I like to tell in this context, but one which sort of goes to the preparation that I mentioned earlier. We worked with a family in the rural Midwest, and the school got on board. They thought they were prepared, but they weren't. And this is a 7-year-old transgender girl. She started using the restroom, and the parents found out, and all hell broke loose. It got so bad that the school said everyone has to use a single-user restroom. And got to the point where parents were first of all using their kids to bully her, and they were being very mean to her. And the parents started calling the principal, calling in threats of physical violence. One father told the principal that if he caught this girl in the girl's restroom, that he would turn her penis into a vagina. A 7-year-old girl. They were not prepared, and she developed PTSD, and so she had to move schools. And again, special education was critical in helping that happen. Obviously, you know, we don't want it to get to that point, but that's why special education can be helpful. So just quickly, what are the remedies and options? So administrative remedies, you can file a complaint with the U.S. Department of Education's Office for Civil Rights. It's based on regions, so you just need to look at what region, what office covers your region. Most likely it's going to be Atlanta for you, in North Carolina, and certainly Georgia and Alabama and Florida. You have to file it within 180 days of the discrimination. And the one difficulty with this is it requires parental consent for anyone under 18. So that is a bit of a hindrance. You could also, if your child or client's rights were violated, privacy rights, you can file with the Family Policy Compliance Office, which administers FERPA and enforcement for FERPA. It's a totally useless office, I'll be honest with you. And I've really not seen much get done there. And then your legal remedies, you can file a lawsuit in federal court under Title IX or the constitutional provisions. There's no exhaustion requirement, meaning you don't have to go through OCR to get to court. And then if you're going to go the special education route, you need to file a due process petition. It's unclear whether or not you have to exhaust the Title IX claims, for example, in the due process petition. That's hasn't been looked at by any court yet, but I think you probably have a good argument that it's not, that you don't have to exhaust administrative remedies. And we are actually out of time, but I'm happy to stay here and answer questions. Thank you all so much for sticking with us so late. Oh, and just in case, that's our contact information. If you want to reach out to us, please do. Any questions? The video's still rolling if you want to ask. All right.
You're actually booked till 5:30.
Well, I mean, it ends at 5.
4 to 5:30, if you want.
Really?
Yes.
Well, then, sorry. We have about half an hour for questions. We don't have to rush somewhere.